Center. I know a few of you who've worked with us before, but for those of you that haven't, we are a legal services provider on Skid Row. We're actually the only one. And our work primarily focuses on housing and homelessness. And one of the ways in which we are working on combating homelessness in LA and ensuring that everybody has access to safe and affordable housing is to work with the homeless veteran population in LA. The homeless veteran population. So as of 2016, the last numbers that I received, in LA County alone, there are more than 3,000 homeless veterans. So these are men and women who are not sheltered. They're not living in any specific place, but actually out on the street or some other place as of last year. So that is a travesty and should not be happening. And one of the things that our office is doing is working with folks who are suffering from mental and physical illnesses because of their time in service, helping those folks actually get housed, get benefits that they're supposed to be getting, and really removing the obstacles that are standing in the way of these people getting back on their feet and getting inside stable housing. So today, the presentation on discharge upgrades and how that work relates to homeless veterans getting back on their feet. The presentation is going to be led by two of Inner City Law Center staff attorneys, John and Henry, and they will tell you about the process. They'll tell you what discharge status means. There's a lot of military jargon and terminology that's very important to learn if you want to work on one of these cases. They will also be highlighting the importance of doing this work, how it actually impacts veterans and the clients that we see in our office. And then at the end, they'll do a little bit of a cultural competency on working with veterans and some things to keep in mind. And then I'll close it out at the very end by just talking about how you can take on one of these cases if you're interested. Manat has been a great partner for us, and I think we have a half a dozen vets cases currently ongoing with your office, if not more. So you have a great resource internally, folks who are taking on their second, third, or fourth case, but you also have a great resource and partner in us. So I will turn it over to John.
Great. Thanks again, everybody, for coming. We're going to take the better part of this last 2 hours to go through a lot of what Vidya has talked about, give you a very kind of quick overview of this type of work, the clients that you're going to be working with, and how to really effectively advocate for them. At the end of this, if you take on a case with us, we've got a large brief bank that contains sample briefs, sample doctor's letters, sample records requests, citations to the major case law as well as the regulations in this area. So although we're going to touch on that a little bit today, we're going to save a lot of the nuts and bolts for that brief bank and today really kind of go over the importance of this work and what it looks like. Like Vidya said, we've been working with Manat for years now, and a lot of the hypos that we're going to go into and some of the cases that we're going to talk about and the examples are from real life cases, both that have been resolved favorably that Manat attorneys have worked on, as well as cases that they're currently working on. So again, just a brief overview of today. Vidya's already talked a little bit about Inner City. I'll talk more about the history of our Veterans Project. We'll talk about what bad paper or a less than honorable discharge is, how that affects a veteran's eligibility for a variety of different types of VA benefits. We'll go into the connection between bad paper and mental health, specifically mental health symptoms and disabilities in service leading to discharge. We'll, again, kind of run generally through what the discharge upgrade process looks like and the beginnings of what a successful application or appeal could look like. Give you some guidance on how to go about the process, talk about what it means to work with veterans, with folks that are survivors of trauma generally, and then talk about kind of next steps and what it means to take on one of these cases and setting up maybe that first meeting with the veteran you're going to be working with. So here's our objectives for what we're trying to do today. The goal is for you to have a better understanding of all of these different areas before you end up taking on a case with the veterans that you're going to be working with. And yes. Bad paper is essentially any discharge that's less than honorable. It's military terminology for a less than honorable discharge. We'll talk about it in a little bit, but the DD 214 is the discharge document that every veteran gets when they leave service. And anything less than just something that says straight up honorable can be considered bad paper. And we'll go into the different levels of discharge and kind of the benefits that you lose as a result of having something less than that. So again, the goals for today, what we want you to have a better idea of before you go into this work. That being said, Henry, myself, Melissa, the director of our Veterans Project, and really any of the other attorneys that you end up working with through Intercity are going to be there kind of as you move along in this process. Whether it's to help set up that first meeting with the client, get in contact with doctors, review first, second, third drafts of briefs as we go forward. So while these will be your cases with your veteran clients, we are going to be able to be there every step of the way to kind of make sure that this works and is effective for both you as well as the clients that we're working with. So Intercity Law Center, like Vidya said, we are the only legal services provider on Skid Row. We got there in 1980 when Nancy Minty, who is the founder of our organization, a UCLA grad, set up essentially a legal services clinic in a trailer in the back of the Catholic Worker Soup Kitchen on Skid Row. We've grown quite a bit since then. We are a staff of about 45 now with a little over 20 attorneys and actually growing in the next 6 months or so, looking to hire for a variety of new positions. That being said, we're still on Skid Row and we still focus on housing and homelessness issues. Our Veterans Project, like the name suggests, focuses almost exclusively on working with homeless and chronically homeless veterans, which means that for the most part, the veterans that we work with are in shelters and transitional housing facilities in and around Los Angeles. Henry works at a shelter on the West LA VA campus called New Directions, focused on helping veterans who are either recently released from prison or part of some sort of rehabilitation or mental health program, get back on their feet and otherwise get stabilized. We also run a clinic out in Hollywood that's specifically for Iraq and Afghanistan veterans, so typically younger male vets. We run a clinic down in Long Beach through a women's shelter down there that's specifically for women veterans. But the idea of our project is really to be able to go to the places where our clients, where our veterans are at, and be able to provide them the services that they need in a way that makes sense for them and in a way that's as easy as possible for them to access our services, given the other kind of real life stressors and traumas that they have going on in their lives. So like Vidya said, homelessness in Los Angeles generally is an issue. Homelessness amongst veterans is also an issue in LA County. There's some good news and maybe a silver lining to some of these stats in that the number of homeless veterans in Los Angeles County has gone down over the past 5 to 6 years and continues to go down. Like Vidya said, I think the most recent numbers are somewhere closer to 3,000 vets that are, either living on the streets or living in temporary, unstable housing. That's great news. It means that a lot of the money, both federal, state, and local, that have gone into tackling this problem is working. And it means that we've got a lot of good people committed to doing this work. What that means for the people we're still working with is that we're working with a lot of folks that are chronically homeless, folks that have mental health issues connected to their service, oftentimes substance abuse issues related to that. And so we are working with the folks that need our help the most. And I think it's important at this point to emphasize that, these cases, these discharge upgrade cases are not easy. We're going to go into some detail here in a little bit about why that is. But there are cases where attorney involvement is huge, is crucial, is often the difference between, repeated denials and ultimate success. Again, we'll talk in a little more detail about what success means, but in a nutshell, it means, one more kind of step up, one more push forward to achieving that sustainability, achieving that stability in life that was missing for whatever reason. It means having a piece of paper, having a discharge that looks good to prospective employers in a way that a less than honorable discharge unfortunately just doesn't. And so we'll talk more about that later. So, and move on now. But before we jump in, like I said, we've got some hypos, we've got some questions that we want to ask you, kind of that are more case specific. But I wanted to just open it up right now to see why some of you guys are here today, why you're interested in working with vets. If anybody feels comfortable sharing.
Can you guys hear me?
Yes.
Okay, this is Brandon Riley. I'm in Orange County.
Hey, Brandon.
Hey, how are you, John?
Good.
Thanks for doing.
Brandon's one of the attorneys that's been working on a couple discharge upgrades with us.
Right, and thanks for doing this. Yeah, I mean, I have a very sad story of why I initially got interested in this, which is that one of my childhood best friends took his own life after returning from Iraq around 2008. And so that has always kind of made me interested in helping out because in retrospect, I saw the signs of mental health issues. He wasn't involved in bad paper, but any way to help this population has been something I've been passionate about. And secondly, and just more practically, I think once, as a busy attorney at this firm, once you get involved in one area of the law like this and one at-need population, you kind of feel compelled to keep doing it and kind of leverage that expertise as opposed to spreading yourself around it, for all the other causes that may be needed. So I've tried to endeavor to keep working on these cases, and they've been very fulfilling.
Thanks, Brandon. Is there one kind of takeaway from the work that you've done so far, whether it's a client story or something about maybe the more lawyerly parts of the work that struck you that you feel like, for people that are maybe a little bit newer to this, you'd want to share?
Yeah, I mean, I think the work, avails itself to both litigators and transactional attorneys. I think the common thread is you're just telling a story, and I think the challenge is taking what the veteran can tell you, but also really pouring through the documentary record and just connecting all the dots and figuring out what really happened. And I've been surprised at how compelling a story you can really kind of piece together through these things. And these aren't little kind of quibbling procedural things. A lot of the times, these are very clear instances of injustice and just bureaucratic mistakes that are really egregious and have a direct impact on these individuals' lives.
Great. Thanks for sharing, Brandon. Anybody else? All right. Well, we'll have opportunities to talk and share here in a minute. So let's move on. I want you to grab, if you haven't already, the packet and move to the back. There's a case study for a veteran, pseudonym Aaron Mason, and I just want you to take a couple of minutes to read through it. It's just a page. It's the second to the last page of the packet. And then also, while you're reading that, on the fourth to last page of the packet is Aaron's, what's a redacted DD-214, but it's the same client's DD-214, which, as I was saying earlier, is that kind of ultra important discharge document that follows the veteran kind of wherever he or she goes. So when you're done reading the case description, take just a minute to look at that as well. The DD-214, it's the fourth to last page in the packet. It's his discharge paper. All right, so keep Aaron's case in mind as we move through this, because we'll use it to kind of answer some questions about eligibility, as well as kind of how to tackle a case like this when you're just starting a discharge upgrade. But for now, what are some of the differences or the disparities between the case study, the description of what happened to him that you have, in the DD-214? What are some differences that you notice? Or maybe what's not there on the DD-214. Yes. Yeah. It's not very legible. There's a lot of information on there, but it doesn't say a lot. And I think the one thing that, a prospective employer or, someone looking at this form is going to see is the narrative reason for separation. I mean, that's the thing that's probably, it's not in military jargon or lingo. It just says he was separated for a pattern of misconduct. Exactly. Yeah. It does. Yeah. There's nothing about his accidents. There's nothing about what happened to him. There's nothing about, other than the fact that he, has a combat action badge, nothing that describes what exactly he experienced. Why might this be a problem for somebody like Aaron? Right, right. And it's something where, someone that sees this that doesn't know him and is, trying to make a snap judgment on, whether to, accept him for school or, consider him for an application for a job interview, is going to pass right over this because they're, folks are told, especially folks that, are hiring veterans or working with veterans, that the DD-214 is important. But the problem is that it doesn't have a lot of this backstory. So what we're trying to do, first and foremost, is upgrade the discharge, especially, in cases like Aaron's where the less than honorable status and the narrative separation don't adequately reflect his service. And one of the ways that we do that when we're putting in these applications and appeals is to tell that story to a board that might not see it from, the DD-214, as well as some of the other personnel paperwork that, may hint at some of the things that happened, but just don't go into that level of detail. So I'm going to kick it over to Henry right now to talk about a little more of the nuts and bolts on what these discharges look like and how they affect eligibility.
Thanks, John. Hi, so my name is Henry Bouchot. I'm another staff attorney at Inner City Law Center. I served as a judge advocate in the United States Marine Corps from 2010 to 2015, and I'm going to lead you through some of the types of bad paper. So John talked about the fact that there are multiple types of discharges. The first two that we can talk about are honorable discharges and general discharges, which they also refer to as under honorable conditions. It's not guaranteed that you'll receive an honorable simply for reaching the end of your contracted term of service in the military. It is possible to receive a general discharge if you've received under a certain level of performance and conduct marks, but this is typically not the case. Usually if you get to the end of your active service, you'll receive an honorable discharge. Nevertheless, a general discharge is, in many ways, good paper in the sense that you still qualify for many, really most benefits that are available through the VA. However, it's important to keep in mind that something like 90% of veterans receive honorable discharges. So if you have a general discharge, there's some stigma attached to that in the sense that, there's something different about you, and why did you not receive an honorable discharge? So I don't think it's, I guess, maybe it is a little unlikely that you would get a general discharge that you're being asked to upgrade to honorable, because so many of our veterans really actually receive other than honorable discharges, but I guess it's a possibility that you might. Then there are uncharacterized discharges, which I believe are primarily given to people who serve in the military but are discharged at an entry-level basis. So imagine somebody who gets hurt during boot camp or during initial training and then are separated because of their medical issues. Those people can receive uncharacterized discharges. And then let me skip one and go to bad conduct and dishonorable. Those two types of discharges are discharges that require a court-martial, or in other words, a criminal trial, or a plea agreement at a criminal court where a military member will receive criminal due process, and so forth. The main, primarily, we have veterans who have other than honorable discharges or undesirable discharges. These are veterans who, like, the client that we have there in the summary, who had some problems in service. Their service was a mixed bag, and then, for whatever reason, they are separated administratively from the military. They receive due process. They have a right to a board, but for various reasons, we often see board waivers, military personnel agreeing to waive the right to receive a board and receive due process. Usually you'll see that in the context of drug use. Oftentimes a command, which is the prosecutory authority in the military, will agree to allow somebody to discharge with another than honorable rather than face the prospect of jail time. And the important takeaway is an OTH has significant stigma associated with it, both in the nature of the name and the fact that so many veterans receive honorable discharges. It can be very difficult to get a job with an OTH, or with basically anything that's not an honorable discharge. And like John said, the DD-214 doesn't really tell you that somebody's dad was dying and the veteran went AWOL or went UA from their command to go be with their ailing father and got kicked out. It doesn't tell you that they were suffering from depression after a deployment. It doesn't tell you that, maybe they developed schizophrenia in service. It just tells you that they were kicked out, and that service was not honorable. So here's a image of the section of the DD-214 down near the bottom that will discuss the type of discharge. I won't go into this in significant detail because by and large we will have screened and reviewed these cases, provide you with significant guidance on what their discharge status is. But just so you're aware, we'll go through this really quickly. So here you see in line 23 that they were discharged, that the character of service was under other than honorable conditions, and that the separation authority, in other words, the provision in the, here it would be the Marine Corps Separations Manual, and you can find these manuals online if you're interested in seeing what they say. But here this person was separated. It doesn't say here, it just says misconduct, but likely for a pattern of misconduct. And one thing you should know is that it's not. So a pattern of misconduct can be being written up 3 times, or really 2 times actually. Let's say that your CO accuses you of lying to him or her. You can get formal counseling, and your only real remedy is to rebut that counseling in writing. And then let's say a second time you are late to formation by 2 hours because you miss your alarm clock. That could be another formal counseling. Technically, you can be separated under a pattern of misconduct for that. Now, that's not the usual case, but other than taking a case to a board, someone in the military can be processed for separation without really going through too many hurdles. Now, I want to talk about how the VA defines a veteran. Now, just to make sure we're clear, what you all will be working on is a process through the Department of Defense where you are actually trying to upgrade the character of service and also the narrative reason for separation so that the DD-214 actually changes and the DoD makes this change. The VA has separate guidelines for deciding whether to consider a veteran, consider someone to be a veteran. So even if somebody has an other than honorable discharge, that is not a per se bar to receiving benefits through the VA. So how does the VA define a veteran? For their purposes, it's someone who served in the active duty service and was discharged, here's a bit of a double negative, or released from service under conditions other than dishonorable. Are we missing a not? Or is that right?
Other than dishonorable.
Other than dishonorable, right. A little bit confusing, right? Basically what that means is either an honorable or a general.
And maybe an other than honorable discharge.
Just press the button.
The important part about that is, like Henry said, you guys are going to be working specifically on getting these discharges upgraded with the Department of Defense. We're going to talk about discharge review boards, Board of Corrections and Military Records here in a little bit. But if you're working with a veteran with that OTH, that other than honorable discharge, there's a very good chance that at the same time you're working with him or her on the discharge upgrade portion of this, we at Intercity are going to be working on the VA benefits portion of it to show the VA that while they have an OTH, their service is still honorable for VA purposes. Otherwise, something that's not dishonorable. So, although, we'll be providing you guidance on the discharge upgrade stuff, there could be cases where we really are working hand in hand on a similar issue, though sending them off to different administrative agencies.
So I think most people probably are familiar with what we mean by active military service, but I'll just explain very quickly how the reserves works. So as opposed to the active duty forces, there's a reserve component to every branch of the military where you've probably heard about people drilling, people having military members who have full daytime jobs, but are going to the military 2 weeks out of the year during the summers, and also on occasional weekends, like 1 weekend a month. Those persons are not necessarily do not necessarily rate VA benefits. They can, if, for example, they accrue a total of more than 2 years of military service after 1980, or I believe before 1980. It's just any amount, right? Any amount of active service. So let's say, for example, that I joined the reserves in 1995, and I did 5 years in the reserves, finished my time, received an honorable, but I had 1 year, 364 days of active duty training. Or training on a deployment. I would not be a veteran unless one of a couple of other exceptions applied, which I don't think is really necessary to go through at this point. But for our purposes, I think the important thing to know is that there's a 1980 post 1980 cutoff where Congress made it so that it's now required that someone serve for at least 2 years. Practically, I believe every contract for military service is more than 2 years, or at least 2 years. So essentially, if you get to your end of active service, now there are some people who get discharged from the military for medical reasons. I won't touch on that here, but because I don't think you're eligible for that unless you have at least a general or an honorable. So,
if this active duty service issue comes into play in any of the cases that we're working on, we'll tackle it on a case by case basis.
Okay, have I confused everybody yet? Okay, just a quick recap. Very basic. There's two types of discharges that come from courts martial, right? From criminal misconduct, and there's one that basically everybody gets when they don't get in trouble, and then another sort of middle discharge, which is the general discharge, which is a little bit more rare, and then the other than honorable, undesirable discharge, which a whole lot of veterans got or have gotten, and particularly recently as we've drawn down from Iraq and Afghanistan, you see a lot of misconduct that was previously sort of overlooked as we increased the amount of troops during Iraq and Afghanistan, and then treated very in a more draconian way once we were drawing down and trying to reduce troop strength. This eye chart is talking about how bad paper affects your eligibility for veterans. You don't have to scramble your brain looking through every column here. The main takeaway I think you should have here, there are a couple actually. One is that an OTH is going to remove, by and large, all the benefits that you would have otherwise received as an honorably discharged veteran. That includes health care, the zero down VA loan. You can't even, they actually, at least when I was in the Marine Corps, we would literally take your uniforms away from you. We'd confiscate them and send you out to the front gate of 29 Palms, California, and then make you walk to the bus stop from the gate. It's not it's not the happiest of moments for somebody who initially joined the military thinking they were going to do big things. And then with the general discharge, the main thing to know is that the GI Bill requires that you have an honorable discharge, and the GI Bill, especially the post 9/11 GI Bill, is a significant lifeline for veterans in that those veterans who are enrolled full time in college or graduate education receive a monthly housing stipend, which in California is around $2,500. So you see a lot of veterans who get out of the military, especially young veterans, and use this as a way to transition from the military to the civilian workforce. Without an honorable discharge, a veteran is unable to qualify for the GI Bill and get that education or that housing stipend. Okay, so I think I sort of answered that question a little bit, but any thoughts on how a discharge upgrade would affect Aaron's eligibility for benefits? Yeah. Yeah. Yeah, so particularly in Aaron, that's a great point, that it would help him get veteran benefits. And I think in his case, particularly the ability to receive mental health counseling through the VA would be really helpful in his case, as Brandon mentioned. Was Brandon right? Combat veteran like him with two Afghanistan deployments and one Iraq deployments is potentially dealing with some difficulty adjusting, to put it nicely. And so, that gap where that veteran is not getting the treatment that he or she needs is a real problem. both to that veteran and to society. So yeah, definitely in Aaron's case, that's a game changer. And from my perspective, one of the great things about working on these cases is that when you are able to either upgrade a veteran status with the DoD or with the VA, you could really see the change happen like very quickly, knowing that they have a little bit of, some of my clients only receive GR, which is general relief from the county. Now you're talking about $221 a month as their sole source of income. So, I mean, I could spend $221 by lunch, I don't know how I would get through the month with that. And so to know that you're now eligible for the GI Bill, and can educate yourself and get a better job, get a job, or to get a little bit of money to pay for rent, can be dramatically a life-changing experience, particularly here with the high cost of living. Okay. So I'm going to turn it back to John to talk about bad paper and mental health.
So Henry touched a little bit on kind of some of the disciplinary issues that can get you discharged from the military, but I think it's important to note here that this can really be anything. It can be a laundry list of things. It can be commission of a serious offense, civilian type convictions, either misdemeanors or felonies that might warrant jail time, but it can also be things that in the civilian world would never become issues, whether it's being late for a doctor's appointment, being late to formation, disobeying a commanding officer's order, or disobeying a boss's order, something like that,
or adultery, fraternization, disrespect. There's a lot of military only crimes
Yeah, absolutely. Thank you. So plenty of things that wouldn't warrant much of anything in the civilian world that nevertheless can affect a veteran's discharge status, and as a result kind of affect the rest of their life, their job prospects, so on and so forth, moving forward. So here are some narrative reasons for separation that we typically see: misconduct, drug abuse, alcohol rehabilitation failure. For veterans that discharge post the repeal of Don't Ask, Don't Tell, homosexual conduct, discharges based on personality disorders. And I want you to see these because I think it's important to know that in doing this type of work and in working with veterans on getting discharge upgrades, we're talking about not only changing the actual discharge status, honorable, general, other than honorable, but also removing or changing the narrative reasons for separation. So getting a veteran's discharge upgraded to honorable, is one thing, but also helping them remove whatever the narrative reason for separation was, to take it out altogether, or to change it into something like convenience, separation for convenience of the government, is huge. When they take this document to a job application or an application for school. I know that Manat is currently, attorneys at Manat are currently working on a variety of these different types of cases. We actually have Don't Ask, Don't Tell cases placed right now with Manat attorneys, I believe, here in LA and potentially one in San Francisco as well, that are being appealed to the Federal Circuit Court, which is frustrating that it had to get there, but exciting that y'all are working on that work. So we'll talk again more about that in detail, but wanted to give you an idea of what you're looking at here. And so now I want to talk really kind of about the meat of this and the majority of the cases that we take. When we take discharge upgraded cases, by and large, we are taking cases where a veteran's mental health issues, whether or not they were diagnosed in service, contributed to the misconduct or the behavior that ultimately led to their discharge. The vast majority of the veterans that we work with in this context have been diagnosed with some sort of mental health issue, and often that's post-traumatic stress, military sexual trauma, traumatic brain injury, depression, or really a host of other issues stemming from some sort of military-related trauma. And we'll go into the process for getting the discharges upgraded in a minute, but the idea essentially is to show that the veteran's bad behavior, whatever it might have been, was a result of this mental health disability, and as a result, whatever was happening in their life, in their service, was a mitigating factor in whatever it was that they ended up doing. And as you can see here, and I think as you'll learn as you jump into these cases even more, a lot of these mental health disabilities have as their symptoms things that could cause misconduct in the military. A lot of the major symptoms of post-traumatic stress are things like hypervigilance, or what's called exaggerated startle response, reflexive behavior, depression, irritability, attraction to high-risk behavior, things that are going to result in problems like this: going AWOL, testing positive prohibited substances, disobeying a lawful order, being late. Unfortunately, symptoms that all too often go undiagnosed in the military. There's, I think, an unfortunate reality that, for folks that are in, especially if you go in to the armed forces young, you want to, be able to do your best, and you're encouraged to tough it out, get through things that in a civilian world you might go to a doctor for, or see a counselor for, or a psychologist for. And so there is a tendency, unfortunately, to kind of push forward when taking a step back and getting help might really help in the long run. So oftentimes you'll see cases where, a veteran, after having been discharged, finally gets diagnosed with, whatever that mental health issue is that's been troubling them. But in the service, you won't see that 9 times out of 10. You'll see, disciplinary actions like non-judicial punishments, Article 15s, things that Henry's going to talk about in a minute, that really mask an underlying issue. And so, to preview it for you a little, one of the kind of big tasks that you'll have, and some of the legwork that you'll have to do is to, comb through the military records and, connect the dots, show where an instance of misconduct, is really, masking some sort of more deep-seated underlying mental health issue. So given that, oh yeah, go ahead, Henry.
Yeah, and I think when you see some of the records in these cases, it's hard not to jump to the conclusion that, this person, made serious mistakes. Maybe they deserve their discharge. But I think you really have to get yourself in the mindset of being their advocate and really trying to find, trying to tell the story that did not come out during their military service. I think it's important to understand that in the military there's troop welfare and mission accomplishment, but troop welfare is much farther down the list of priorities of mission accomplishment, particularly during as we've been fighting multiple wars on multiple fronts. And so a lot of what you see is people just sort of falling through the cracks or getting swept up in the system. And so it's imperative that we as advocates are trying to cull that information and those experiences. They're gonna help put them in the most favorable light.
And I'm going to have you come up here now and use your JAG experience to talk about the nuts and bolts of some of these discharges.
So I covered some of these already. So the military criminal justice system is governed by something called the UCMJ, the Uniform Code of Military Justice. And there's a multiple tiered approach to punishment and rehabilitation that begins on the most bottom rung with, actually it's not on here, but I mentioned counselings. So informal and formal counselings make up maybe the bulk of how the military handles sort of petty misconduct and even more serious misconduct. But definitely the lower level, petty activities. And you see it in Aaron's case where first it was something small like being late. And then it was something a little bit worse like the credit card issue. And then it became, the stress that resulted in what he was charged for is destruction of government property. But initially, they probably counseled him formally in what they call a 6105 counseling in the Marine Corps. I think they call it page 11s for. It doesn't really matter. You'll see the narratives in their personnel records, and you'll sort of come to use those to piece together what happened. And so it's interesting because you can use those to put together a timeline of how somebody was messed up, but you can also use that to try to understand where things started going wrong, either mentally or in their family lives or financially for them, and how close those were to deployments. So good example is I have a client who developed schizophrenia during his deployment to Iraq, and I was able to put together a timeline showing that he assaulted, tried to stab a non-commissioned officer probably days before he got back from Iraq, if not that very weekend. So pretty important to be able to piece together that timeline. The next rung on this multi-tiered system is non-judicial punishment, which is the maximum that you can receive at non-judicial punishment is, I believe, 30, maybe 60 days of restriction, which means like timeout, or being grounded. It's like going to your room and after work and you can't, play video games. It's really like that. Withholding of pay, that type of thing. Now the military member has to accept non-judicial punishment. They have the right to go to trial, but oftentimes there's pressure to accept that. And then the court-martial process. Summary court-martial is the lowest level, most basic type of court-martial. It involves a magistrate who acts as the court, as the prosecutor, as the defense attorney, can adjudicate up to 30 days of confinement. I actually was the magistrate in a bunch of summary court-martial. It's kind of weird. You're like in a room by yourself with the Marine, and you're like reading off a script. It's just the two of you, and you're like, okay, now I give you 30 days in jail. It's like bizarre situation. Do you have any questions? Like that type of deal. I'm sorry. Can you? I couldn't really hear you. Yeah, I think this subheading could have been phrased a little more accurately. It's more like types of punishments that could lead to discharge. So a non-judicial punishment will not result in being discharged per se, but could possibly, and then certainly multiple of them. Like I said, 2 formal counselings within 1 enlistment is grounds for pattern of misconduct. Usually will not be the case. And then special and general courts-martial are your misdemeanor and felony courts, with special being your misdemeanor and general court-martial being your felony criminal court. And then Chapter 10 is the section of, actually we call it something different in the Marine Corps, but do you know about this a little more, John? I don't remember.
I think it's part of the UCMJ, but it's the chapter under which these the discharges and the reasons for them are written down.
Thanks, John. So, to wrap things up on bad paper and mental health, the important takeaway is just how much of a slippery slope it can be. You can be on top of the world in the military, think that nothing bad is ever going to happen to you. Kind of like Aaron. Aaron was he was motivated. He signed up for Army Ranger training, signed up for, to be his unit's armor. He seemed to really enjoy the military. Went on multiple deployments, and some some physical injuries that he experienced along with other types of trauma, specifically here his exposure to mortar attacks. It says combat, and he has a combat action ribbon, so he probably took and returned fire, potentially, struck improvised explosive devices, or saw others do the same. And so, that really led to a change in personality for him, doing things that were out of the ordinary. And you can see how that type of behavior would be not only could be easily confused with just, you're just not a good guy. And so, and then again, with the threshold and the patience being so low for misconduct in the military, particularly during a drawdown scenario, you can see how disciplinary proceedings can lead to bad paper very quickly. Okay, I'm going to have John come up here and talk about the process for obtaining a discharge upgrade.
So before I jump in the interest of time, we had an exercise right before this, and it's one of the last couple pages in your packet, connecting the misconduct with the discharge status. I won't hide the ball for you on this. You can see there's 5 or 6 kind of short hypos describing what happened to a service member, and then as a result, what their discharge was. We try and get you to guess what the discharge status would have been. These are all real cases that we've worked on. The discharges are totally random, though. I think one of them received an honorable discharge for something that would have seemed much more serious than someone that got an OTH. Really, the idea behind that exercise is to highlight that there really is, although there are, very specific kind of codified punishments for certain behaviors, certain misbehaviors in service, there really is no kind of expected rhyme or reason to how someone ends up being discharged. Like Henry's alluded to a couple times, what you do in the military often matters less than when you do it. If our country needs troops for whatever happens to be happening, whatever conflicts we're in, you are more likely to stay in than if we're in a drawdown situation and you could do something, or maybe 1 or 2 things that are relatively minor, and be out very quickly with an other than honorable discharge. So that was just the point of that exercise. And now I want to talk about the more legal side of this, kind of what it is that you'll be doing and kind of the work moving forward. So in applying for a discharge upgrade, there are 2 administrative options for doing this. You can either apply with your veteran to one of 3 discharge review boards or one of 3 boards for corrections of military records. I'll explain what the differences are in a little bit. The reason why there's 3, there's the Navy, the Army, and the Air Force. Any Marine that has been discharged less than honorably would apply to or appeal that discharge decision under either the Navy's DRB or the Navy's BCMR. Again, kind of just nuts and bolts for you to know moving forward. So here are some of the differences. There is a 15-year statute of limitations to apply for a discharge upgrade with the Discharge Review Board. There's only a 3-year statute of limitations with the BCMR. However, the BCMR often waives that 3-year statute of limitations in the interest of justice. If you can explain, for a variety of reasons, why the veteran hasn't sought a discharge upgrade up until that point, they will waive it. As we'll see in a little bit, oftentimes this takes the form of, let's say, a veteran that was discharged with bad paper after the Vietnam War. Vietnam War, let's say he was discharged in 1972, got diagnosed with PTSD maybe recently because that wasn't even a recognizable disability until 1980, and is now applying for a discharge upgrade. That would be a good reason to waive. Well, he can't waive the 15-year with the DRB because that's not waivable, but you would go to the BCMR in that context, and they would waive the statute of limitations. The DRB is, I think it's helpful to think of the Discharge Review Board as a district court in the federal court, the context, or really a court of first impression. This is where you would go with an initial claim or an initial ask for a discharge upgrade. They have a limited ability to make changes. However, for the variety of things that we're going to be asking for, upgrading from a general or an OTH to an honorable, or asking to change the narrative separation, they can do that. The other nice part about the Discharge Review Board is that they provide the option for a hearing in front of the board itself. In that same context, the BCMR doesn't. What we've seen, and I think some of the folks that have worked on these cases at Manat can attest to, is that we and anyone that does this work ends up being much more successful, or more successful more of the time, if you and your client are able to appear at a hearing, as opposed to just a records review. That being said, we've been successful in records review with well-written briefs too, but it's something to keep in mind when you're looking at where you want to take this case. Yes. So it depends on the board. They have travel boards that come around. They also have an option for video hearing, but and I wish I could give you a better answer on this. They've stopped doing those, at least with the Army and the Navy, and I've heard that recently they've restarted the video hearings, but we haven't gotten confirmation on that. In large part, there's a kind of lack of transparency with how they do this. We typically have requested, when we request a hearing, or if we're working with someone that requests a hearing, we request a video hearing, and then, if not possible, a hearing in DC or with the travel board, and then we'll get a response back one way or the other.
Sorry. But one thing we've definitely seen is better outcomes when our pro bono attorneys have gone to the hearing. So just something to keep in mind, that if the time and the resources allow, then absolutely go ahead and do it.
And again, this is something, this kind of procedural choice decision on kind of where to go with the case is something that we will be happy to talk about and kind of work with you on as you move forward. Obviously, given the time limitations, there may be a decision made for you already, but if there's a choice to be made, we can kind of talk through the specific facts of the case. So I think this is important, and it's important in contrast to the VA appeals process, as well as to the importance of the work that you do. There's a presumption at both the Discharge Review Board and the Board of Corrections that there is a regularity in the conduct of government affairs. Essentially, that means that it is presumed that the military, when they discharged the veteran, did it right, and that there were no errors, and that the right decision was made. So it is our job, and it's your job, to overcome that presumption with substantial and credible evidence, either that there was an error or that there was something inequitable about the veteran's discharge. We'll talk about that in a minute. But it's in contrast to the VA benefits process, one of the things that we work on, where the benefit of the doubt goes to the veteran. So one way to think about it is, in that context, they're reviewing cases for character of discharge or service connection for disability benefits de novo. And while it's helpful to have an attorney in that context, it's crucial and vitally important to have one here, where you're working with, suffice it to say, a much less favorable burden of proof. So here are the legal standards for discharge upgrade. You have to make the argument that the discharge was either improper or inequitable, or potentially both, depending on what happened. Most of the discharge upgrade cases that we work on fall under the inequitable prong of this, but I think it's important to understand both, because you want to make sure that you're making all the arguments you can. So we'll talk about improper or impropriety first. This is where there was an error of fact, law, procedure, or discretion that occurred, and as a result of that error, but for that error, the veteran's discharge would have been different. I think a couple examples are helpful here. So we worked with a veteran in the past who received a less than honorable discharge, in part because the the Administrative Separation Board wrongfully considered a civilian conviction that he'd had before he entered the military that he'd reported when he entered the military. And so, as you might imagine, you're disclosing all of that to the military. If they say, look, we understand that you got this DUI when you were 19, but we're going to accept you, they can't then use it against you in your discharge proceedings. Because they did, that was improper, and we were able to argue effectively to have that discharge changed. Brandon's working on a case right now with a veteran, and I think he's making both an impropriety and an inequity argument. But the impropriety argument was made on the basis that the veteran was discharged. The narrative reason was for a condition that was not a disability. It was a personality disorder. But given, and I won't go into the details, or maybe I'll let Brandon do it, but the conditions under which his disability had manifested actually warranted him being put through a medical separation board and diagnosed at the very least with a disability, as opposed to administratively separated for misconduct. So again, an error in the way that the discharge happened, as opposed to something that might fall into the equity prong of this. It was a personality disorder disability.
Another good example would be so with post-traumatic stress disorder, it's a requirement that a veteran be screened for PTSD. And so if, for example, you were to see a case like Aaron's where he has combat experience, you would definitely be on the lookout for a PTSD screening in his or her personnel files. I'm not sure if there's been success with those types of claims, but it'd be certainly worth bringing that issue up in the upgrade.
Thanks, Henry. And so the other example, the other kind of main example of a discharge based on impropriety would be where there's been a change of policy and that change has expressly been made retroactive. So if a veteran was discharged less than honorably under Don't Ask, Don't Tell, and since 2011, or I guess obviously prior to 2011, he or she would then be able to appeal that discharge on the basis of impropriety, given that that's been repealed, and in this case at least made expressly retroactive to apply to any veteran discharged under this policy prior to the repeal in 2011. So now I want to talk about discharges or discharge upgrades based on equitable arguments, because this is probably where the real meat of your cases are going to be. So as a general rule, veterans discharged that have been discharged inconsistent with disciplinary standards at the time of discharge would fall into this category. This is a really broad kind of catch-all category. I think one that maybe elucidates it a little bit better is this one. So where current discharge policies and procedures are materially different than those that led to the veteran's discharge. So Henry brought up the example of a veteran diagnosed or reasonably asserting post-traumatic stress at the time of his discharge is entitled to a medical exam to determine whether or not he has or she has that disability and how it could have affected their service. Now, that didn't go into effect until 2009. Quite a few of the veterans that we're working with have been discharged prior to 2009. So with that change in policy, if you're dealing with a veteran that was, say, discharged in 2008, and given the new regulation, if his discharge could have been different, if he'd received that exam, that's an argument that you can make under equity. It's slightly different than the Don't Ask, Don't Tell argument because it hasn't been made expressly retroactive, and it's never cut and dry whether or not that veteran would have been entitled to that exam. But it's certainly an argument that you could make. And then again, a large general catch-all category that we tend to focus on and hammer on when we're doing these cases is showing that the veteran's capability to serve or their quality of service was impacted in some way, and often impacted by what was either diagnosed or undiagnosed mental health issues relating to the misconduct that led to their service. I think, Henry, I wanted to kick it to you. You're working on a case right now, I think, where you've got a good example of this, someone that served for quite a long time, right prior to their discharge, if you want to talk a little bit about it.
Yeah, and it's actually a case that we are offering here to Manat to take. And so this is a veteran who served in the Navy for about a total span of about 19 plus years. And if you know how the retirement system works in the military, it's 20 years to an annual or a lifetime annuity of like, your top year in service or whatever. So he definitely a difficult thing for him not to be eligible for that retirement. I believe he served. So there's up to like 9 rungs of the enlisted sort of hierarchy, and he probably reached like 8 of the 9, if not 7. And so he had multiple deployments to Kosovo, to Africa, in like contingency operations, humanitarian relief operations, including a deployment where he was responsible for picking up human remains and people who were injured. But his last deployment to Iraq, he was with the Marines in Al Anbar province, the Sunni Triangle, doing convoy missions. I don't know the extent to which he experienced combat, but I do know that his unit saw a really significant amount, received a number of combat action ribbons and Purple Hearts, and upon return from his last deployment, he began having some significant issues, began self-medicating. Anyway, this resulted in a positive urinalysis for cocaine and methamphetamine. Pretty unusual case for somebody that senior to be discharged or to have a positive urinalysis for a narcotic of that magnitude. It usually is something you see among lower ranks and the younger veterans. So he has five children, or I think maybe 4 children and a spouse at the time. So you could imagine the issues he was experiencing at the time. He's now 100% service connected for PTSD, despite his other than honorable discharge. So you see how it's possible to have the OTH yet still be eligible for VA benefits, and that was largely in part to the work that my predecessor Waldo, who was an Army veteran, who did on his behalf. And so now is our opportunity to try to upgrade his discharge to either general or an honorable. Just a bit of a forewarning for anybody who works with him. He does not have a phone, so it is challenging to get in touch with him. He is on the VA campus, which is not far from here. So I think this is definitely one of the reasons why I look for you all to maybe take his case, because of the ability to stop by the domiciliary there. It's like a barracks where you could talk to him. Really nice guy. Yeah.
But yeah, and I think this case is so indicative of many of the cases that we get. I mean, maybe not the length of his service, but one where we're really able to make the argument that the veteran's quality of service, at least up until he or she experienced whatever that trauma was, whatever that injury was very good. I mean, we have someone that, was an E8 or an E7 before the issues really started occurring, had, quite a bit of responsibility, had garnered a variety of awards, had served in combat, had done prior enlistments. So these are all points in service, good quality of service that you can point to show that his overall service was honorable, kind of despite what happened to him and despite what the instances of misconduct are.
And the fact that he's been service connected for PTSD through the VA is, I think, going to be really helpful to you, because it's one thing to have some, statement from the veteran and maybe some civilian records, but to have the VA's stamp of approval there, I think, given the bureaucratic nature of the Department of Defense, will be a significant help.
Yeah, and I think it's important to note, too, we keep talking about the VA benefits process, and although that's something that you're not familiar with, it's something that, whether it's this case or other cases, we'll want to to kind of work with you on and explain to you more on a case-by-case basis, because it does matter. Like Henry was saying, this veteran, is service connected for post-traumatic stress. Now, that doesn't necessarily mean that the Discharge Review Board or the Board of Corrections for Military Records is required to take that and say, take that as binding evidence that he did have PTSD in service and that it did contribute to his discharge. However, they can't help but take that as at the very least persuasive evidence that this is something that the VA, another administrative agency that works exclusively with veterans, recognized that this veteran had something happen to him in service that not only impacted his ability to serve, but impacted his job prospects moving forward. So again, a lot of the arguments that you're going to be making, especially ones that don't kind of fall into some of those more kind of finely tuned impropriety categories, are going to fall here. Being able to talk up the veteran's quality of service and how that relates to, good period of service, trauma, misbehavior related to that trauma. I'm going to take just a few minutes here to run through kind of some of the statutes and regulations that you'll see, and that'll be kind of the most common in these types of cases. Again, there'll be reference to these both in the sample briefs as well as, copies of the regulations in the memo. So I won't go into too much detail. But this is the regulation that I was talking about earlier, the 2009 regulation that mandates medical exams prior to separation for all service members diagnosed with or reasonably asserting post-traumatic stress or traumatic brain injury. So depending on when your veteran was discharged might depend on how you take a case like this, right? Because if a veteran was discharged in 2010, perhaps was diagnosed with post-traumatic stress either by a military doctor or civilian doctor, and didn't receive this medical exam, you'd be making kind of the more cut and dry improper argument that he was improperly discharged because he didn't receive this exam. That being said, even if he was discharged prior to 2009, you've still got the equity argument to make. The argument, yeah.
So the PTSD screening is, I think, like a quick survey. So it's, it'll go through a series of questions of: do you experience nightmares, difficulty sleeping, hypervigilance, and so I'm not sure that, there's necessarily a lot of room to get it wrong. Since it's just a calculation of, does it add up to PTSD? And to my knowledge, no, it wouldn't be. I think the requirement is that you do the exam.
Yeah, I mean, right? I think the shorter answer to your question would be it would be an equitable argument. We'll talk in a little bit about kind of the types of evidence that you'd want to collect to make this successful. But you would, in that particular context, hugely important that the veteran that you're working with is, actively seeking mental health treatment, has a psychologist or a psychiatrist who could ideally in this context write a letter of support or an opinion, not necessarily disproving the opinion in service, but providing more context. Because like what Henry said, these exams in service, though it's good that they're giving them, are typically being given by a doctor who is seeing that veteran, that service member, for the first and last time. And providing, like you were saying, Henry, kind of a very pro forma exam that, could be wrong, but also could just not, detail exactly what's going on. So you'd be following the equity track there. So then again, some more of these more liberalizing regulations that you're going to definitely be citing to in the briefs that you're working on. Another one from 2009, and this is related specifically to the boards, not necessarily to what happens in the military. But if you have a veteran that after discharge, in this case while they're applying for a discharge upgrade, asserts or can show from their kind of post-service records that they do have post-traumatic stress or traumatic brain injury, then the actual makeup of the board, in this case the DRB, the people making this decision, has to have one medical professional on it. Now, we've seen plenty of cases where that fall into this category where it doesn't seem like the medical professional's opinion had much or any weight, or that they even gave an opinion, which is an issue in and of itself. But at the very least, there is a requirement that there be someone that is at the very least familiar with these disabilities and the impact that they can have on service on the board. I say that because, it doesn't, kind of abdicate our responsibility to help the veteran get good medical evidence from their treating doctor, but it is helpful nonetheless. So here's some more recent ones. Again, liberalizing regulations related to post-traumatic stress. These specifically are for the BCMRs. And basically they require that special attention be paid to VA service-connected PTSD and PTSD-related conditions. So like what Henry was saying, you've got a veteran who now is recognized by the VA as having post-traumatic stress related to service. This memo, without unfortunately going into too much detail, at the very least requires these boards to consider that and to treat that as a relevant substantive piece of evidence when they're making their decision. Even more recent, some that came out last year, and this relates to statute of limitations that I talked about earlier, a memo in February 2016 that basically says for cases involving PTSD and TBI that have previously been denied, so previous discharge upgrade cases, there is no time limit. They can reapply whenever. And that they're supposed to be reviewed de novo by the boards. So this is a second and sometimes third bite at the apple for some of the folks that say applied, maybe back in 2005, 2006, and got denied without the benefit of these regulations. And then a more recent even policy shift in the Navy is that if the service member is diagnosed with a mental health disability in service, then that service member must be processed through a disability evaluation board as opposed to a more punitive administrative separation board. This regulation is so new that we're not sure exactly how it's going to shake out, but at the very least signals a shift in the Navy, at least in the DoD, that in the discharge process, they are going to prioritize the fact that someone has a disability over the fact that they did something wrong. Now, we're not sure exactly what impact this will have on cases, but it's nice to know that, injury is going to take precedence, hopefully, over what someone did, especially if that injury contributed to the misconduct.
And that's not an insignificant change. Having served in the military, I can tell you that there's really a tension between accountability and people who are suffering from mental illness. And so I think during the time that I served, it was still very much tilted in favor of no matter what, you should be held personally accountable for your behavior, regardless of your mental health condition. And so it sounds like there is some recognition that it may not be as clean cut as that would presume.
Yeah, and I think this point is your point's well taken, especially in the context of what I'm going to talk about now, is that the boards oftentimes get the law wrong. The National Defense Authorization Act, the act responsible for a lot of the statutes that I just cited, requires the boards to look at the totality of the veteran service and take into account mitigating factors like disability, family issues that were happening at the time, things that could have impacted their ability to serve. What we've seen all too often is these boards applying a more insanity defense criminal law standard for culpability. We see them saying, we recognize that the veteran was diagnosed with PTSD while he was in service. However, there's every indication that he knew he had the ability to understand right from wrong. As a result, his use of drugs or his positive urinalysis for whatever it might have been, still results in, is not going to warrant a discharge upgrade. So to the extent that we can, write the brief to head them off at the pass and get them to kind of reverse that wrong thinking before they make an initial wrong decision, that's great. If we're working on an appeal, Brandon, I think, is working on one right now, where despite a incredibly well-written and argued brief, they still made this decision. It's still good to have it on the record and be prepared to, make that argument, whether it's at a hearing or, written in kind of a more formal appeal. So I want to go back now for just a few minutes to look at Aaron's case and get some ideas from you on what types of evidence you think might be helpful to submit with his discharge upgrade.
I'll jump in if you guys can hear me.
Yeah.
So this hypo at least is in large part based on a client that I'm working with right now, and what's been helpful with this is with this case is that this service member there's extensive mental health evaluation and health evaluation records where it's very clear that he disclosed this assault, the assault that's referenced in there to the mental health professionals, and that they essentially didn't do anything with that information, including one of the professionals, a psychologist, even noted that his suicide attempt was directly related to the assault which had happened a couple of years earlier. And despite that, she recommended him for dishonorable or other than honorable discharge. So there was a very clear kind of paper trail where you could see where they should have adequately accounted for his past, and that being an explanation for what happened to him directly before he was discharged.
Yeah, so the case that Brandon's talking about, I think, is a good one for this. It's also a bit rare, unfortunately, that the in-service records would be that substantive and that voluminous as a result, in talking about his mental health records. So, and again, I think that goes to the importance of what you're saying is getting a letter of support from a current treating physician, both in this case to kind of re-emphasize what his disabilities are, but more importantly to connect that to, his ability to serve. Obviously the people that, the psychologist that he's seeing now, didn't know him in the service. However, they're still qualified and capable of making an opinion based on the symptoms that they've experienced and what the veterans reported about their time in service to make a statement, not only saying he has this diagnosis, I believe that it's connected to service, but I also believe, given my extensive treatment, ideally of folks with post-traumatic stress, that the behaviors that he exhibited in service are, part and parcel for someone that was dealing with this at the time, especially if they were dealing with it in a context where there's a stigma attached to it, or reporting an assault in the case of Aaron, or in the case of Brandon's client, led not necessarily to better treatment or more thorough treatment, but to a recommendation for a bad discharge. So yes, I'm both referencing those records in service as well as getting a statement from whether it's a civilian doctor or VA doctor is huge. Anything else? Any other types of evidence that would be helpful in a discharge upgrade case like this? So I should jump in at this point in the cases, and I think, Henry, you alluded to this earlier, but at this point in the case, we will have for you the veteran's entire military personnel file, their VA medical records. Most of the time, if the veterans are eligible for VA healthcare, we'll have those for you. We'll have their civilian health records, oftentimes if they're not, as well as their military service treatment records. So those will all be part of the file. But I think it's helpful to know, like, when we're looking at personnel records, those don't necessarily have everything. They'll obviously have the DD-214. They may have some recommendations for promotion, some awards, but more often than not, there won't be the full text of the award, or you won't get a full understanding of why they received the commendation that they did. That being said, the veterans oftentimes keep those. It's something that, even for folks that have been, unstably housed for a period of time, these are important documents. And frankly, they're oftentimes the originals explaining what exactly they did that was so great that got them the promotion or that got them the Army Achievement Medal or whatever it might have been. So if you see that on a DD-214, asking the veteran to see if he or she still has those, because again, that will go towards showing what their overall quality of service was in putting together an application like this. I think other things that are helpful are, letters from friends and family members. Ideally, folks that knew the veteran both before and after his time in service, and before and after whatever trauma it was that, caused or contributed to the misconduct. Letters from mother, father, brother, sister, explaining, what happened to the veteran and what his or her life was like is huge. I mean, and it goes back to what I was saying earlier about filling in the gaps for the discharge review boards. Anything else, Brandon? Anything else that you've